Sean, the one and only Sean Taggy there.
What's up, man?
What's going on?
Not much. Just just trying to learn about these trusts.
Right on. Out from Tennessee, you're going to hear about it.
Yeah, all the way from Tennessee, man. You guys are putting out some good stuff. I just saw an email. It's like, let's just listen in.
Oh, good. I got you and a bunch of other people on board. I just plugged you for a second so that I could test audio and video and stuff before we jump into this.
Yes.
So, you can hear me all right?
Yeah.
Sweet. I was messing around with the audio here for a second too. I think. Tell me what you see here as far as the screen, Sean. Do you see this video of me? Is that moving around? If I move it around?
And all I see is you and then a blank white of your screen.
Well, I want to make sure that we see. I'm way less important to see than my screen, so let me see if I get rid of this for a second. And turn that on, and I want to make sure that we see this, and I want to make sure we're recording here. So recording is taking place. We'll jump here in just a second. Thanks for hanging tight with me. And on the screen here, we should be seeing. Still nothing, Sean, on the screen?
All I see is white now.
Just a white screen, huh? Oh, that's weird. Give me a second here.
It says now viewing Jeff Breglio's screen, but it's just all white. My
Interesting. All right. Let's try.
Oh,
Does
there you
that
go.
change anything? What's that?
Yeah.
Is that better?
Yeah, I can see it all now.
Okay. Let me go down here. I want to make sure my questions is open. Let's see. Nate Lambert or Buzz, Dave Heaps, Brian. And if you want to shoot out a Michael Hanrahan, just type in a quick question. Sorry, what was that, Sean?
Nate Lambert, Sean Taggy from Memphis, man. I know Nate.
Yep. I got a bunch of guys on here. Yep. So Dave, thanks for raising a hand. You guys type in a question. Do you see where the prompt is to type in a question? I'll make sure that's working well. We can do a quick response there. Awesome. Thanks, Sean. Thanks, Dave. Sweet. So I think we're good to go. Timing wise here, we're a minute after. And we're recording. Everybody can hear me. Sean, I'm going to go back and mute you just in case you have any background noise or something that we don't have any interference there. Feel free to type in your questions or answers into that box if you have them as we go along. So for me, it's super weird to try to sit in front of a computer screen and pretend like there's a bunch of people out there listening, although I know you guys are, I can't see you. So I'd much rather present in person than here online, but we make it possible so it's convenient for everybody. So anyways, hope we're excited today. We're going to talk about asset holding trusts. What is an asset holding trust? I'll refer to it throughout the presentation as an AHT, just as abbreviation, so you'll know that's an asset holding trust. We'll talk today about what they are, how they're used, and how they can be created, and see if we have some time here at the end to, let's see, Dave Heaps telling me I got an echo. Part of the problem, Dave, is that I have an office that just echoes, and I don't know if there's much that I can do about it. I don't know how much feedback. I tried to plug in a different microphone. Let me see if that other microphone is registering yet, because I plugged in a microphone that's better than my computer's own microphone. That's better? Okay. Thanks, Dave, for the feedback. I'll try to adjust where I'm sitting. Maybe that'll help. I do appreciate the feedback, though, so if it seems like it's bugging somebody, nothing worse than watching an hour-long presentation and having some nasty feedback or echo the whole time. All right, so let's jump into this. Let's see here. So what is a trust? Basically, before we jumped into this, I wanted to make sure we understood, at least conceptually, what a trust is. This may be basic for some of you, but some others that just understanding what the heck a trust is can be difficult to comprehend. So a trust is a legal document that can be comparable to a business entity in many respects. So it's like an LLC or partnership or corporation. It does create a legal entity. It's formed through a contract, just the same way an LLC or partnership corporation is. However, unlike a business, it is not registered with the state. So it's private in that sense that it doesn't require any kind of state registry. I will say as I head into this, other than Sean, and there may be others out there who are outside of the state of Utah, there can be states where these trusts are registered, but typically they are not. Most often they're private. Which is one of the benefits we'll talk about later in why we use these trusts or where they're beneficial is because of their privacy component. And that's why they're a popular tool for real estate investors that are out looking for this privacy. The way that I explain to most people what a trust is and understanding the trust structure is that a trust is like a ship. A ship must be first built or created, and then it has to be given directions or instructions as to where it's going to go. A ship must also have a captain, so somebody's got to be in charge of that ship. It doesn't necessarily own the cargo, right? Just because I'm a captain of a ship, it doesn't mean that I own the cargo or that I own the ship, but I will be responsible for signing documents and guiding the ship to its ultimate direction and destination. A ship, as I mentioned, does should have cargo. If it doesn't have any cargo, whether that's passengers or actual cargo that it's taking us somewhere, then it doesn't serve much of a purpose. But ultimately, if that's either passengers getting from destination A to destination B or getting cargo from A to B, it's for the benefit of somebody else. So that the ship is serving that purpose. And so as you think of that analogy, as we move through this, it's helpful to understand, okay, when we create the trust is the ship. It needs to be built or created by somebody. It needs to be architected. It needs to have directions and instructions given to it. And that is all done by the grantor. So let me see here. I'm wondering, I won't be able to see my mouse here on the screen. Dave, you've been responsive. Can you let me know if you can see my mouse on the screen if I move that around? So the grantor here is the builder or creator of that ship. And as you guys create the ship, or as we create these trusts, we'll want to remember and keep in mind who that grantor is. And naming the proper grantor will be important, and we'll talk about that a little bit. But just remember the grantor is the one that's creating the trust and giving it instructions. After the grantor, we have a captain. So who the captain of a ship, the title of the captain of the ship is a trustee. So as we create these trusts and we nominate a trustee, just remember that trustee is like a captain. Trustee doesn't own the cargo. It doesn't necessarily have any legal responsibility, but it will be the one to sign documents and play an important part in directing and controlling the property. The cargo in the ship is the titled assets. So we can put things in and out of the trust. We do that by titling assets. So we'll talk about that in just a minute. And ultimately, the trust is created to serve a purpose, and it's going to go to the benefit of somebody else. And so, sweet, thanks, Dave, on the feedback on the mouse there. So that's awesome. And if we go through, and then the trust has to serve a purpose. My thoughts are, if you, just responding back to Jonathan real quick in a question he asked, how do I know if the trust needs to be registered in a particular state? You ought to check either with us. You can do a little bit of research and find out on your own. If you want to reach out to an attorney in a particular state to find out if they have to be registered. Like I said, probably more often than not, it's not going to be required to be registered. But on occasion, you may want to confirm that just to make sure. I would also say, if you would like, my preference would be to, you can certainly type in some questions. I'm going to reserve answering those questions probably until the end, because I want to make sure that we get through the content that I laid out today, and then we can get to those questions, the Q&A at the end. So if you post a question but don't see me answering it right away, we'll see what we can do to get to those at the end. Cool. Any other questions that I missed here? Awesome. Okay. So looks like you just see the first screen with a definition. Should see this now, what the trust structure is. You guys are seeing this screen of what the trust structure is with this little table here. No, why is it not something? Could be there's a delay here, Dave. If you're still seeing the definition of what is an asset holding trust. So let me make sure we're cruising through there. All right. How are properties placed into the trust? So this is a process you'll hear and be familiar with, the process of funding. So if we create a ship, but we never put cargo into the ship, and it's supposed to go somewhere and do these cool things, but it doesn't hold anything, it doesn't serve much of a purpose. And so we need to make sure those properties are, property and assets are placed into the ship. That's called funding. And you can do that by changing the title of an asset. So when we change the title of an asset, so if we change the title of property and real estate and name the owner the name of the trust, then we have basically placed the property into the trust or under the trust control. If that makes sense. So it's simply a matter of changing title on something, and that's how we place it into the trust, by changing its title. If the name of the owner of a vehicle is your personal name, and you change the title on the vehicle to show now the name of the trust, then we place that vehicle into the trust. And so typically the way that things are placed into trust is by changing the title on the document itself to the asset. Okay. Obviously, you probably have all heard that there are lots of different types of trusts. We hear trust used kind of ubiquitously, and there's a bunch of different placements for it and different types of trusts. So I want to just make you aware of the different types of trusts. Structurally, they're all the same, but they can all operate a bit differently. There are two major categories of trust, though, that are really critical to be aware of, and that is a revocable trust and an irrevocable trust. So while we'll talk about different types of trusts, we'll talk specifically about one type of trust today, but they are categorized typically into both revocable and irrevocable trusts. Today we're going to talk about asset holding trusts, which are revocable, but they are a bit different than traditional revocable trusts, and we'll talk about those. We'll get into the details here in a minute. But I did want to make sure that you're all super clear that not all trusts provide asset protection. So let's talk for a second about asset protection versus privacy. Asset protection basically means that if you're sued and people find out what assets you have, it means that there's still a barrier or there's no attachment to those assets. It's pretty much impenetrable. Asset protection means it creates a wall between judgment creditors and the asset itself. So even if you are sued and they try to come after it, it's protected. Whereas privacy, which basically makes it difficult for people to find what you own or what you have, but once they do find what you have, it isn't a wall anymore. So I've heard that asset protection is like the wall around your castle, and privacy is basically like the smoke and mirrors. Well, it doesn't actually prevent somebody from getting to you. It can make it hard for them to find you. Hopefully that's a helpful analogy again to, remember we're talking ships and castles and moats and smoke and mirrors today. So, so let me go through for a second here the different types of trust and what protection they provide. So if you want asset protection, which creates a barrier, then you're going to need an irrevocable trust or an asset protection trust, which we're going to talk about here in just a couple weeks. You should all register for that webinar as well. On this side over here, we have no asset protection, but these are trusts that can provide privacy. And that includes revocable living trusts. In just a minute, we'll talk about the distinction between land trusts and asset holding trusts. But just be clear that these are all not for asset protection, creating a wall, but for privacy only. which privacy obviously can be a form of protection and defense, right? It just isn't impenetrable. So how are the asset holding trusts today that we talk about different, okay, than these other trusts that we just mentioned? And basically, these asset holding trusts are, structurally very similar. They are simple versions of traditional living trusts that you may use in estate planning, but there are a few additional tweaks that particularly relate to control, and we'll get to that part. But essentially, you still have a grantor, you still have a trustee, you still have a beneficiary, and we still need to make sure the assets get funded into it. So structurally still the same, but they're a little bit different. Now, many of you may be asking, why are we talking today about asset holding trusts? All I've ever referred to or heard them is land trusts. And so I want to be real clear and help you understand why you may hear those terms interchanged and what the distinction is. So a land trust is a creature of state statute. So it means that means it only can be created in a state that specifically allows a special type of trust, which is called a land trust. So it's actually a technical term of art. These sort of land trusts are only technically allowed under state statute in Florida and Illinois. There may be another state or two out there, but I'm not aware of them. Okay, but they have very specific laws governing their operation within the state. So unless you are in a land trust state that creates those type of documents, then you cannot use or actually own and control a land trust under the technical term. But people often refer to these types of trusts, which we'll be talking about today, as land trusts because they operate so similarly. So they're used in real estate investing. They're used a lot of the time for the same purposes. The reason we bring this up too is because there are some title companies and other institutions that have a real issue if you use the word land trust, but you're not in a state that actually allows land trust, because it can't be created if you're not in a land trust state. You can have essentially an asset holding trust which operates very similarly. It's just not called a land trust technically. So how are they different? One of the biggest differences is that a true land trust does not have a grantor. So in those few states where you have land trusts, they aren't required to actually name or list a grantor. And so unless you're in those states, you're required to have a trust that actually specifically spells out who the grantor is. And that's what these asset holding trusts, because we're not here in Utah in a land trust state, we need to have trusts that list a grantor. So the grantor is typically the one that can amend or revoke the revocable trusts. And so these asset holding trusts are different than your revocable living trusts in the sense that an asset holding trust has a grantor, but instead of retaining the power to revoke or amend the trust as normal revocable living trusts do, the asset holding trust allows the grantor the ability to pass the ability to revoke or amend the trust to the beneficiaries. So it's a minor little distinction, but it makes a big difference. So the grantor, in that sense, it doesn't retain the ability to revoke or amend the trust, but instead transfers that on to the beneficiaries. So that's the one way that an asset holding trust is similar to the revocable trust, but different, and how it's a tweak or two different than a true land trust. So Dave Meadows, your question, is this trust like a land trust, and is a land trust used in Utah? Hopefully what I've just talked about answers both of those questions. So the question is, why are we talking about these trusts if you don't know, or how they can be used? We'll talk about this today. So the primary reason these trusts are used is to hold title to properties. So for that asset or that privacy component, right? If all 50 states in the country recognize trusts, whether those are true land trusts, revocable trusts, irrevocable trusts, or these asset holding trusts, all of them, they can all hold title in all 50 states. The trust can always hold title. And they're primarily used because they create privacy and not asset protection. although we wish they could do both, but the asset protection component is going to come in a different form of a trust. Okay. They can be used to wholesale or to flip properties as well. Obviously, as you'll see through the rest of this presentation today, that doing that in those can be beneficial, but also comes with additional complexity. And so we have a 90-minute webinar on how to do this if you're interested in using these trusts for wholesaling or flipping. I would also say if you're interested in using these or want to use these to wholesale, that you ought to also attend our class coming up, also on our website, to register for that, on wholesaling, particularly to understand wholesaling here in Utah and how laws are changing and what's happening here and how we can wholesale legally here in Utah. So, but just know that they are used for those purposes. They can be beneficial in those purposes and for those purposes. But today we want to talk primarily about their use in holding property long term. Hopefully most of you understand why privacy is important. If you're building a portfolio of rental properties or have assets, you understand that the first thing a plaintiff's attorney will do if you're being sued is assess what the defendant, or you in that case, in that lawsuit, has in terms of money, and to determine if it's worth pursuing legally and to ensure that the attorney gets paid. So he's going to do a cursory review and see, what does this defendant have? Does he have a good job? Does he have assets? Does he have property? And if that attorney has a difficult time finding your assets or your name on public records, they are likely to turn away their clients or go away. And so if we make it hard for people to find assets that you have, then that's the benefit of privacy that typically, in that case, lawsuits have a tendency of going away at least easier. A lot of times that's a cursory investigation that attorney is going to look at. And if he can't find you on necessarily in public records, state public filings, entities, or certain things, then, they're going to go away quickly. And these trusts help to hide property, particularly, real property. So how does the asset holding trust create this privacy? We'll share that with you. The asset holding trust creates privacy in the sense that the asset holding trust, as I mentioned, is not recorded or filed anywhere. It's not filed with the state like the way that an LLC or a corporation is. And it's not recorded in that sense. So, and the names of the grantor, so the ship builder, and the beneficiary, so the owners, I guess, or the people that get the benefit, is always private. So there's no way to know who owns the property unless you provide a trust agreement to them. I mean, you basically have to show them who that is by providing the trust agreement to them. So it's always kept private. Again, in a lawsuit, that only comes out if you have a subpoena that basically subpoenas those records, and you have to turn over that trust document. Otherwise, nobody can find out who is a beneficiary. The asset holding trust is the entity, however, that takes title to the property and is therefore the owner. So again, if you bought a property and you use a trust, an asset holding trust, to take title to the property, then for all intents and purposes, the trust is the owner of the property, and you don't show up. Second, you do need to know that the trust name and its trustee are the only things that show up on county records. So it is important to know that if you decide to be the captain of the ship and manage it in that sense as a trustee, then your name goes back to showing up. And we'll talk about how to deal with that trustee component again and make sure that you want to control the property, but you don't necessarily want to show up on county records. How do we go about that? One thing that's really interesting is that some states don't show, or counties outside of the state of Utah don't show who the name of the trustee is on county records. So it makes it even more appealing and more private. State of Utah does, all the counties in the state of Utah do require that that the trustee is listed in the county records. So if they search for the name of the trustee, that trustee pops up. Okay, so if neither of these things include your name or your address, these public records and property title searches don't include your name or your address, then you simply don't appear on county records searches or title searches. and it doesn't look like you really own anything, and that would encourage somebody else to basically disappear, as far as an attorney who's trying to sue you, to just go away. So how can this this asset holding trust be used in conjunction with an LLC or a series LLC? And this is a diagram that I created to kind of help explain how this works. So the diagram is best understood by starting at the bottom and understanding that down here at the bottom we have, in this yellow, we have property A, okay? And property A has an address, and let's say property A address is 123 South Main Street, for example. So 123 South Main Street property, we can transfer that property into a trust. We would create a trust document first, and we might call that trust the A trust, because it's the property address, or may connect to the property address. We'll talk about naming the trust here in a minute too, and how that's done, how these things get created and built. But I just want you to understand conceptually how these work with entities. So the property itself is transferred into the trust. The trust, again, as you recall, has a grantor who's created the trust, a trustee who's a captain of the ship, and a beneficiary. So in this case, the beneficiary is the person who owns really the benefit of the property, from a tax perspective, from an income perspective, from a liability perspective, is the beneficiary. And so in this diagram here, this top blue rectangle is a series LLC, and each of these little nodes below it are little sub LLCs. Now this could be a traditional LLC with a parent holding company and sub LLCs below it. So essentially what we would do is we would name the beneficiary of the trust A as this LLC right here above it. And by naming that beneficiary in the trust, your LLC, we have now connected your trust, which is the one on title, to the LLC itself. I know I went through that pretty quick, so I'll go through it real quick again. First of all, the trust is created, and the property is transferred into the trust with a warranty deed. And the trust, when we created the trust documents, we listed the LLC as the beneficiary. So technically, that baby LLC in a series LLC, or the LLC that's a holding company, would be first listed and created so that everything else could then connect to it. So in that sense, from a creation standpoint, we start at the top holding company, a parent LLC or a series LLC. From there, create a baby LLC or a subsidiary LLC if it's a standard LLC. And after that, we would create the trust document below it. After the trust document is created, then we can transfer the property into the trust. So from the procedural standpoint, that's how it's done. We need to start with the legal structure and create the trust document, and then we can transfer the property into the trust. Okay. Several questions I see coming up. I am going to address those questions through the presentation. So Tate, looks like you've got a couple questions on there. We'll definitely get to those before the end here, okay? So we'll address those here. So why would you use a asset holding trust in conjunction with a series LLC? My phone recognizes every time I talk about series LLC, my iPhone thinks I'm talking about her. So let me get a second to put that in the drawer. I'm not talking to Siri when I say series LLC. All right, so why would you use in conjunction with a series LLC? So again, remember that the LLC, or the asset holding trust itself, does not create asset protection, but a series LLC or an LLC does. So if the first level of owning the property in the trust creates privacy, and then connecting the beneficiary of that trust, who's legally responsible for it, being your LLC, now we have asset protection. So essentially we have both privacy and asset protection when we combine asset holding trusts and LLCs. Okay, So one reason why we use it in conjunction with a series LLC is because it creates privacy, the trust creates privacy, and the LLC creates the asset protection. We'll talk about in a minute about how using these sort of trusts can reduce the red flags for due on sale clause in loan documents. Many of you are concerned with transferring property or transferring real property to an LLC or potentially to a trust or anything else, and the concern with the due on sale clause. So we're going to talk about that specifically in just a minute, but just know that transferring, and we'll understand why, that it does reduce and can reduce the red flags. And again, right now, there's only about 15 states that recognize a series LLC for owning property. As many of you are likely aware, a series LLC can be a pretty, I'll call it slick vehicle, legal vehicle, to holding multiple rental properties without all of the tax filing documents and annual renews with the state and all the different complexity that can come with having a lot of entities. A series LLC can streamline that, but if it's only recognized in 15 states, then what do you do about owning a property in a non-series LLC state? Well, in all 50 states, as you recall, they all recognize land trusts. So what we can do is we can hold title to that property in a non-series LLC state in a land trust first, and then connect the land trust back to our Utah or Texas or Delaware series LLC, so that again we have one legal entity and one tax filing and no requirement to file any state filings, meaning state registry, in any other state. So we keep basically one legal entity that can now hold property and hold assets into all 50 states. But the only way to really do that is to connect a series LLC and an asset holding trust. Okay, so that's a very slick connecting piece. It's probably not something that many are aware of how that works and how we can make that possible. And so certainly want to reach out to us if you're building a portfolio or interested in building a portfolio of rental properties across multiple state boundaries. You will otherwise be creating LLCs in each state and have all different state registration and renewal requirements and registering as a foreign entities and lots of different bank accounts and tax filing returns and a whole slew of other things. So chat with us, get in touch with us if that's something you're looking at doing and interested in seeing how that could work for you as you build a portfolio across multiple state boundaries. All right. So let's get into how do you create these trusts. One of the questions that was posed is maybe why would I use these trusts as opposed to just an asset holding trust? Well, one of the benefits, as I mentioned, is that we can create a separate trust for each property, but the cost of creating these trusts is much cheaper. So you can have two options when it comes to creating these trusts. You can essentially buy our forms and our videos, which would give you the documents to create them on your own. That's $4.95 to do that, and you can literally create as many trusts as you like. So that makes it easy for you to reduce legal costs and give you the tools you need to do it over and over again. You can have us create the trust for you. That's $3.50 each. So every time you want to create a new trust, you can have us create one for you. You'll need a trust name, trust date, a property address, grantor, a trustee, and a beneficiary to create those. It's pretty much all the information that you have to plug and play on each one of those. So they're fairly simple once you understand how they work. That's why most often we'll recommend that you essentially purchase our forms and get a video on how to create them on your own, unless you just really don't want to take that on, and then we can help you out. So the first thing that we'll talk about is what do I call the trust? So you're always going to start with the word the. Every trust is going to start with the word the, and typically the name of the trust is going to end with the word trust. In the middle, pretty much anything goes. So here are some recommendations for your options. Most of my clients, I recommend that they either use part of the property address. So again, if the address was 123 South Main Street, then maybe it's the 123 South Main Trust, for example. It could just be the South Main Trust, if that's the only property you think you'll take on South Main. One of the benefits of the naming of the trust is maybe using a nickname that you associate with the property or the home. At some point, you'll have multiple trusts, and if you had 7 properties on Main Street and all of them were called the South Main Property Trust, you wouldn't know by looking at the name of the trust which property you're referring to. So you would want to do name a trust something that would trigger back to you. Some of my clients have found that just use of a code, and they have some algorithm or basically like a key that says this code matches this property, and they can look at that spreadsheet and know which property they're referring to. I would say that's probably less preferable than the pink yellow house or the fourplex trust or something else, right? And so, using that name of the trust, hopefully that gives you some ideas on what we want to call the trust. So this may seem really dumb, but how do we date the trust? You're gonna say, this sounds really super simplified, but it really is important. So the trust has to be created, and the trust is created when it is dated. So that's the most important thing. The trust, it comes to life and is created when it is dated. So prior to putting the asset into the trust, it needs to be created technically. So in a sense, it depends on what asset you're putting into the trust. If you currently own a property, then you could create a trust document and use today's date, and then later transfer the property into the trust. This is because you already have the asset, you already own the asset, which is the home that you're putting into the trust. If you're making offers though to buy a house, then most likely you haven't actually created the trust documents yet. So often people will use in the purchase agreement to create the property, they'll list the buyer as the trust itself, even though the trust hasn't been created, and then make an offer in the name of the trust. Or better yet, in the name of the trustee is the buyer. Okay, if it's accepted, if the offer is accepted, then they actually have to go back and create the trust, but they will need to make sure to date the trust prior to the signing of the purchase contract. So again, technically speaking, the trust needs to be created before the purchase agreement is signed, the date of the purchase agreement. So this is why the date matters. You need to make sure that the trust is actually created before the purchase agreement is created if the trustee of the trust is buying it. If you name the trust as the buyer, then essentially you're alluding to this trust being created. You need to make sure that it gets created in the right time. So this is important. So you're keeping in mind the asset that you're putting into the trust at that point is the purchase contract. Some of you are saying, hey, how do we get a purchase contract into a trust? Well, by naming the buyer on the purchase contract, that's essentially what you've done. All right. So who do I name as the grantor? Now remember, the grantor is the person or the entity that creates the trust and then puts the assets into it. So often if that's you personally and you own a property that you own currently in your own name, obviously the grantor would be your personal name. If you currently own the property in a legal entity, in an LLC, then that person would be the person that owns the property. If again, you are just signing a purchase agreement on the property, then the grantor is whoever you want, but that's gonna be the person that's essentially gotta be the grantor on the trust creating the document. Then your entity, in that sense, if you're buying and you want the entity that will be the beneficiary of the trust, would also be the grantor in that sense. So let's say, for example, you want to buy in the name of if you ultimately want your LLC to be the beneficiary of the trust for asset protection. When you go to create the documents itself, you can go ahead and list the grantor and the beneficiary as the same. Pretty sure that was another question that was asked here was, can one person be both the grantor and the beneficiary? That was Tate's question. So I'll just answer that for you, Tate. Yes, the grantor and the beneficiary can be the same. We'll talk in a second though about who cannot be the same. So remember, ship creator and the ship beneficiary can be the same, but the sole trustee cannot be the same as the beneficiary. So as you're creating these documents, you can't have the grantor and the trustee and the beneficiary all be the same. You can't have the trustee and the beneficiary be the same. The sole trustee, if you're using a sole trustee, and the beneficiary cannot be the same. Now, there's a little bit of area of question here, but we feel like there's a strong argument in saying, okay, so what if, let me see if I can find a structure here. What if, back to this structure here, this trust is, let's say me personally, I'm going to be the trustee of the trust, and my LLC is going to be the beneficiary, but I also only happen to be the sole member or sole shareholder of the LLC that owns the trust. Is that allowed? Because essentially I'm now being both the trustee and the beneficiary at the same time. And so the argument that we make there is that we feel comfortable in saying that the entity itself is a separate legal entity. So at that point, they really are not one and the same. The trustee and the beneficiary are no longer one and the same. Although I happen to be the only member of my entity, it's not the same, not the same entity. So remember that whoever you name as trustee, so I'm starting right back up here. Remember that whoever you name as trustee in Utah and in other states will show up on a title search and on county records. So if you are looking for privacy, if you're creating these LLCs for privacy, then you don't want to use your personal name as a trustee. It's also super important that we talk about the trustee can't be the same as a beneficiary. And remember this, the trustee is the captain of your ship. That means that the trustee, whoever you name as trustee, will be responsible for signing all closing documents, purchase and sale agreements, warranty deeds or transfer deeds. They'll be responsible for turning on or turning off any utilities or anything else on behalf of the trust. So yeah, it can be work for the trustee, whoever you nominate. Essentially, you should choose someone who is available and who is trustworthy as a trustee, because essentially they'll be able to sign documents that can transfer the property. They can sell the property or they can go out and buy other properties in the name of the trust. So you want to make sure you have a great deal of trust in that trustee. Which leads me to, well, what is a commercial trustee? So there are business entities out there that hold themselves out to serve as a trustee for trusts. These include banks, attorneys, financial advisory firms, and others. Typically, they will provide this service, obviously, for a fee. They are in business. These are not charitable institutions, so there's going to be a fee associated with acting as a commercial trustee. This is something that our firm can provide to you, again, so that you're not listed as a trustee on title. We provide this service to our clients for asset holding trusts for their buy and hold properties. It was something that we used to do for clients that were either wholesaling or flipping, but due to the large amount of work that was required to do that, we found that it wasn't financially viable for many of our clients for the work that we had to do and what they needed to get done. So we just don't offer it for any flips or wholesales, but we will do it for clients that want to buy and hold properties. So there's a $200 setup fee for us to get that trust set up and in our system. Obviously, that wouldn't include any fees or costs to actually create the trust itself. That's just kind of the setup fee on our end. and then it's $99 a year. It would be prorated the first year you set it up, and then $99 a year billed to you in January for however long you own the home. When there are requirements for us to sign documents, then the signatures on electronic signatures are free. If we need to print and sign and scan and email back, then they're $25. And if it's a full package of closing documents, it's $50 for a real estate closing. So that gives you an idea. Like I said, there are other banks, other attorneys. I just spoke with somebody at the financial advisory firm. I don't know that they do these sort of services for these sort of trusts, but I know that there are other commercial or corporate trustees out there if you wanted to look for that. Otherwise, other options for trustees may be a close relative who doesn't share the same last name, probably, because that helps. It's showing up on county records. It wouldn't be your last name as well. And so that would be the next best option is to look to a family member or a really close trusted friend that doesn't share the same last name. So here's a question. Can I use co-trustees? Basically, can we have co-captains of this ship? And yes, in fact, we recommend it. You can have a co-trustee that signs the deed and thus appears on title, and then another co-trustee that actually manages the trust or deals with the property. So typically what we will do is when we create the trust documents for our clients, we'll list ourselves as one of the co-trustees and a client as the other co-trustee, so that we actually, our firm will sign the deed that appears on title so that our client doesn't. But then our client as a co-trustee or co-captain is still able and capable as a co-trustee to actually manage the trust. So they're running around and turning on and turning off utilities or signing any other documents if necessary, or just overall managing, maybe that's bank accounts or otherwise that they're able to take care of that we don't need to be participating in. So that keeps them off record and allows us to work with them and both have control. Obviously, in order to do this, the trust document has to specifically state who those co-trustees are and authorize them to act independently from each other. Otherwise, co-trustees would be required to both sign everything. So it's more of a checks and balance at that point if the co-trustees are required to act collectively. So a good trust document to enable the flexibility would be specific about them being able to act independently from each other. The question here is, can I swap out the trustee after the title is recorded? Yes, it's not super uncommon to do this. Some people will do this often. You could get it recorded and have us listed as a trustee or somebody else listed as a trustee, and then change that to somebody else. But it can create problems. Doing so can create problems. And the reason why is the benefit of doing this, of having somebody else listed as a trustee and then swapping out afterwards, is that you don't show up on title, right? But the drawback is, guess what? That you don't show up on title. So there are utility companies, maybe title companies, other organizations that get heartburn if you're trying to act as a trustee, but you're not the one listed on title. So you would again need to show that you'd have to show them the trustee designation form that removed the prior trustee and now designates you as a new trustee. So everywhere you'd be going, you would be needing to show them those documents. Again, not impossible, doesn't create anything you can't overcome. It's just something that you should be aware of as far as creating a problem or a potential barrier. And last but not least, obviously, if you if you go through that process of assigning that over to a new trustee, and then later don't have those documents because you failed to keep them in a safe place, then you're going to have to go back and find the original trustee again and recreate those. So, and we, speaking from experience, have seen that, and it created some problems. So go ahead and keep those documents if you create them that removes or has a trustee resignation and appoints a new trustee. Okay. Wow, lots of questions coming in. So we'll have a chance to get to these. This is great. Let's see where I'm at here. Okay, so who do I name as the beneficiary? So for our purposes with the asset holding trust, we would almost require you to list the beneficiary as the owner of a trust. Would be your LLC. The beneficiary in that sense is the owner of the trust. And that's a fine way to view it. So they otherwise own the asset. They're, like I said, they're the entity. The beneficiary is the legally responsible party. So that's the party who will be sued. It's the party who will receive the benefits of income and has, as these asset holding trusts are concerned, the ability to amend or revoke or change the trust. And so the beneficiary and the role of the beneficiary is really critical. Like I said, the beneficiary can be the same as a grantor, it just can't be the same as the trustee. And you can change the parties, all these different parties except for the grantor can be changed. So it's like changing the captain of the ship or passengers. They can all be swapped around. This is really where you start to understand how this can be done in wholesaling or in flipping. So new beneficiaries can be added or removed, and sometimes for a fee, wink, wink. So if I'm under contract and have a property under contract, and my LLC is currently listed as the beneficiary, which means I'm going to get the money through closing and have ownership of that property, I can certainly transfer that beneficial designation over to somebody else, that beneficiary designation over to somebody else. And of course, I would probably want to do that for a fee because now they will own and control the property. And so again, like a quick wink, that's essentially how wholesaling using flip or using these asset holding trusts can be done. And new captains can be appointed in this as well, as we already talked about with a resignation of a trustee and appointment of a new trustee to run the ship or control the property. All right. So let's talk about the due on sale clause for just a minute and how these can help, but what they don't do. And I guess I'm going to make sure that everybody's clear that on how this works. So I actually have the language here from the U.S. Code. This is from the Garn-St. Germain Act that some of you have heard about as relates to the due on sale clause. And so this is the federal statute language regarding this due on sale clause, and it's saying basically a transfer is allowed to have a transfer into an inter vivos trust in which the borrower is and remains a beneficiary and which does not relate to a transfer of rights of occupancy in the property. So if that happens, it cannot violate the due on sale clause. Is essentially this section right here is saying if this sort of transfer takes place, this does not violate the due on sale clause. So a transfer to a trust is a transfer to an inter vivos trust in which the borrower is and remains a beneficiary. So I can take property that I own currently and I can transfer it to an inter vivos trust or revocable trust that we've been talking about, in which I, the borrower, remain a beneficiary. So I've been telling you that your LLC should be a beneficiary and not you individually. And the technicality in this statute says that you have to remain the beneficiary. So the first argument here is that the borrower, me, is the beneficiary still. I'm just a beneficiary through my legal entity. And interestingly, a second ago, we were trying to say that the legal entity and me are two different people. Here, we're just trying to say that the borrower and the beneficiary are one and the same. Again, this is trying to make an argument that, hey, we haven't done anything that would violate the due on sale clause. But you'll see in the next section that it almost becomes impossible if you're going to use this property for a rental. So moving out or leasing to another, and the next clause is and, which does not relate to a transfer of rights of occupancy in the property. So if I have a traditional loan that I'm taking to the property and it transfers, and I transfer the property through this trust into my LLC, and I transfer the rights of occupancy, that on a technicality, then I I have violated or I have enabled the due on sale clause to become activated. Okay, so essentially there is no way to outright get by the due on sale clause. That's what, frankly, all of you should walk away knowing none of what we do can get you out of violating the due on sale clause. Transferring property to an LLC or putting it into a property and having a renter go in there can certainly and absolutely violate the due on sale clause. The reason that investors use this is they lean on the fact that title transfer goes into a trust, which under this statute right here, can be allowed. And if title transfer goes into a trust, banks are looking at, if they are to look at county records, they see that a transfer simply went into a trust, they're likely to or may assume that it was into a revocable living trust and would therefore not violate the due on sale clause. The only way that they can determine and know if it wasn't is if they actually asked for or subpoenaed those records through a lawsuit, and we're able to also determine that you no longer live in the property. Both of those things being satisfied, they could trigger the due on sale clause. Again, most investors, and probably for good reason, are thinking and believing and looking at this saying, hey, banks are not paying attention. They don't know. And if they see something, the first thing they see is a transfer to a trust. They probably don't want to dig too much further because they're assuming that maybe they've transferred to a revocable trust and we don't want to prod. So that's why it's used. I think it's good to know that it does create, that's what I said earlier, it avoids red flags for the due on sale clause. It makes it harder for banks or institutions to know for sure what's happened. But does it clear you from violating the due on sale clause? No. And that's never something I'm going to claim. It doesn't eliminate that process. It doesn't make it so that it's allowed. It just is, again, a smoke and mirrors component. And you should always be aware that that sort of transfer could violate the due on sale clause, and you get 30 days to either transfer the property or pay off the debt. Again, it just doesn't happen very often, and that's why so many real estate investors lean on it. All right, so a couple other questions that come up. So how do we deal with title insurance? Does the title transfer to the trust void the title insurance? It might, depending on how you've initially set up your title insurance policy. Unless that's been planned for in advance, transfer could void a policy. You certainly want to discuss this with your title company in advance. As you make preparations and buying and selling property, let your title company always know that you may be transferring that property to a trust or a legal entity. Good planning will help with that. Also, many title companies and some underwriters will not insure transactions where these sort of trusts are involved. So you really ought to work with the title company that is familiar with how these work and be able to work with them. I see that Leslie Peterson is on the call today with Charger Title. She certainly knows how these operate and work. Title company that we work with here at the Brayley Law Office as well will allow and authorize these sort of trusts to be insured. But you ought to check with the title companies you're working with and see how they feel about it. If not, you may need to find a different title company. What about property insurance? So again, we need to name the trust. Let me start again. The new named insured on the insurance policy should be the name of the trust. So as we change title over and we want to make sure we have good insurance coverage, we need to have the named insured on the insurance policy be the trust. And then we should also make sure to list as additionally insured. Again, your insurance agent will know exactly what these quoted terms are: named insured and additionally insured. There are things that they put into their policies. It's super simple, but they need to name as additionally insured the beneficiary under the trust, which should be your asset holding LLC. And again, you may be working with a insurance carrier that has no idea how this works, or your agent may have no clue how these trusts and series LLCs work at all. You may need to find a new insurance agent that understands real estate investing and these sort of structures. Okay, and there are several of them around town. There are several of them that are national. and I recommend that you seek out one to understand these. A couple other things here. This is the last 2 slides. So your trust is not going to be able to get a bank account. It doesn't have a separate tax ID number, and you wouldn't necessarily want it to. So you will use the beneficiary's bank account for all purposes. Again, it should be your LLC. We'll be able to open a bank account and have the LLC's bank account open for all purposes. From a tax standpoint, the asset holding trust is a pass-through entity to the beneficiary. It doesn't pay any taxes. It has no tax consequences. Everything the trust does gets reported on the beneficiary's tax return. Lease agreements, this is a little bit more complex, but not a big deal. We recommend that you put the trust as the landlord on your lease agreement, and then you sign your lease as the trustee. This allows you to, or whoever your trustee is, right, it would be the one to actually sign a lease agreement. Then when in your lease agreement, you need to write in that the payment instructions from the tenant are to be deposited into the account for the LLC. And then the LLC manager can manage the property as well. So we've covered that pretty quick. We've got down to the end here. I want to show you basically a couple resources, and then we're going to start going through some questions. So much of what we have covered today is also covered in a guidebook that we have generated at the Brailio Law Office. You can find it at www.brailiolaw.com/client info. If you scroll down just a little ways, you'll see our guidebooks, and one of those is titled Asset Holding Trusts. If you click on that, you can download that PDF. It's probably 26 pages long. It does discuss in the guidebook how to do more using wholesaling, if you're interested in learning a little bit more on how to use these with wholesaling. Although I still recommend you attend our class and hear more about wholesaling before you jump down that hole too far. And we'll also be able to substantiate or fill in any gaps if we haven't had a chance to chat about it today. Anything else you need from us, you can contact us for forms or assistance in putting these documents together and helping you get things rolling. And then here, I'll just show you our contact information. Most of you should have that. You're all part of our email list. You know our phone number. So let me see if I can go back through and answer some questions here. One question is, why would you ever use an asset holding trust instead of an asset protection trust? Why not have both if the asset protection trust provides both? So to answer your question, Tate, the basics are that we can create these asset protection trusts, one separate for each property, which is really hard to find true ownership. They can hold property in all the different states. It can be connected back to your series LLC. It's easy to take a property or to dissolve these if needed. Easy to create, easy to shut down. They're very simple. Essentially, from a structural standpoint, the asset protection trust would own the LLC or the series LLC, and then each one of these properties would go into these asset holding trusts. Again, it's kind of a matter of simplicity. It's a matter of flexibility. It would all ultimately roll up to a series LLC or an asset protection trust, depending on specific needs. Otherwise, you'd just be putting all these long haul rental properties disposed into an asset protection trust, which is a possibility, I suppose, but it would depend on your total structure and what your objectives are. Probably wouldn't be the first direction we would head, but that's certainly an option. Some people like these because of how they can connect with their series LLCs and taking ownership in multiple states and creating a privacy component. Again, if I know that there's an asset protection trust, I may see what I can do to pierce it. So one level of defense is the smoke and mirrors, and another level of defense is the true asset protection. All right, Sean out of Memphis, can you do all of this even if you have a conventional mortgage on a property? I think we covered all that today in regards to the due on sale clause and how that works. Obviously, you can make those transfers. Does it create a risk on the due on sale? Yes. Does it reduce the red flags to the banks by transferring to a trust and not to somebody else that's not on a loan or anything else? That's how it works, and that's why it's done. Because it does create like a possibility of it being a valid transfer, and therefore banks aren't as interested or curious. If it was Sean transferring property to Cody, then it would be obvious that it violated the due on sale clause. But if it's Sean transferring a property to the 123 South Main Trust, then because it was transferred to a trust, it automatically becomes a question at that point as to whether it violates the due on sale clause or not from the bank's perspective, and they may not be interested in spending the time to find that out. Let's see, Mr. Man, Nate Lambert. So do you create the LLC first or the trust first? So I hope I went back through that. Structurally, we create the entity first, and then we create the series of the LLC next, and then we create the land trust last. Can it be done the other way? Yes. You just need to pay attention to names and dates of those things. So I could create the trust first and name a beneficiary. I'm getting a little bit complicated here, but I could create the trust first and name a beneficiary without having named created the Series LLC, the baby of the Series LLC first. But I would just need to make sure that when I do create the name of the Series LLC, that the name of the LLC is exactly what the beneficiary is in the trust. Again, if I had a whiteboard up in front of you guys or a way to do that, I wish I could. I want to figure that out because I could draw it out a little bit better on the screen. But essentially, the preferred method and the clean method is to start with a legal structure and a legal series, and then the trust last. You kind of can't screw up if that's how you're doing it. All right, Rick asked, you said earlier land trusts are only recognized in a few states, yet slide 13 says you can purchase in all 50 states. Okay, so Rick, remember or recall that the specific term land trusts as a legal term of art is only recognized, is only created and allowed under a few states. But all 50 states recognize trusts generally. So what we're creating are asset holding trusts or any kind of revocable trust. All 50 states will recognize some form of a trust to take title to property. So these sort of trusts that we create are recognized and can be used in all 50 states. Again, there are only a couple states that recognize specifically the land trust. Okay, so hopefully that helps to clarify. That would be going back to those first couple slides when we said, hey, the problem is that the term land trust can be used interchangeably sometimes. And so you hear even in non-land trust states, people calling them land trusts. They technically aren't land trusts because the state doesn't create and have laws that allow land trusts in that state. But they're just used that, they're called that because it's kind of like the term, just a general term that people refer to them as. The technicality, so what we call them is asset holding trust because that's what they do, they hold an asset. They work similar to a land trust. For all intents and purposes, they are land trust, except for we're in Utah, and Utah doesn't have a statute that allows you to create a land trust, capital L, capital T. Hopefully that answers, okay? Mike Lloyd asked, hey, can an LLC be the trustee? Yes. We talked about how there can be corporate or commercial trustees, so the LLC can be a trustee. You still on county records or on those records, it would show, for example, Cody Backus, trustee of Braylio Law Office, or Cody Backus, manager of Braylio Law Office, who is the trustee of this trust. So they would still have to name an individual there somewhere, even though an LLC is being used as a trustee. But good question, that helps you out. Happy to help give a shout out to Leslie Peterson. She's a rock star at Chartered Title and great for closings, understands these sort of documents and how to structure these deals using trusts. Jonathan Applewhite asked, what about dealing with property managers? Is property management agreement with the trust or with the LLC? Jonathan, this is the one question that I left out but is answered in our guidebook. So I didn't answer that question here, not because I couldn't, I was worried about time. That answer is in our guidebook you can download. I highly recommend everybody does that. So go back to the guidebook, download that as a section on who is dealing with the property manager. Okay? And last question here, and then we'll wrap up. Hour and 8 minutes into this. Would you recommend putting all our flips into trusts? Tate, I would say you ought to reach out to us. That's probably going to be a more specific question to what you're doing and how that operates. It can create a little bit of complexity depending on the number of flips that you're doing and how those are going. There's a variety of different other considerations there. It's possible to put them all into different trusts. We've had clients and have clients that do that. There may be other options for you if you're looking for privacy and asset protection and you're doing trust. I would say give us a call. Let's chat specifically about what you're doing, and we'll decide if it makes sense for you or not. So, anyways, this was recorded today. We'll try to have this available again down the road. If anybody needs to get access to it. Hopefully you all learned something about these these asset holding trusts. See, I almost had a slip there and called them land trusts. And appreciate you being a part of the meeting today. Take a look at our next events and get registered for those. I think it should be good. And I wish you all the best day. Success to all of you. Take care.